6 trials, 4 death sentences, 23 years, 1 man. Most Americans believe there is a wall in the law that says the government cannot keep trying you for the same crime until it gets the answer it wants. That wall has a gap in it. If your conviction is thrown out or your jury can't agree, the state is allowed to start over. In a small town in Mississippi, one prosecutor drove through that gap 6 times against the same man for the same 4 murders across 23 years. Every one of those death sentences was erased. And when the Supreme Court of the United States finally read the record of what he had done, it needed only one adjective at a time: relentless. Determined. This is the story of the 6 trials of Curtis Flowers and of the man who would not stop. His name is Curtis Flowers. In the summer of 1996, he was 26 years old, living in Winona, Mississippi, a gospel singer in his family's group, a young man with no criminal record of any kind. By the winter, he was in a cell, charged with the worst crime his town had ever seen. What happened next is not a whodunit. Nobody has ever proven who committed these murders. Remember that, because this story refuses to pretend otherwise. This is a different kind of mystery. How one elected official was able to try the same man 6 times, lose 4 convictions, burn through 2 juries, and keep going, and what it finally took to stop him. Here is how to watch this film. Count everything. Count the trials. Count the death sentences. Count the jurors, who they were, and who was removed. Because in the end, this case wasn't decided by a confession or a fingerprint. It was decided by arithmetic. The numbers are going to testify, and the last number will arrive from the highest courtroom in the country. Start with the morning, because 4 people deserve to be more than a case number. July 16th, 1996. Winona, Mississippi, a town of roughly 5,000 people, about half of them black and half of them white, sitting at the crossroads of the state. On Front Street downtown stood Tardy Furniture, a family store that had been part of the town for generations. That morning, 4 people were inside. Bertha Tardy, 59, the owner. She had run that store with her late husband and kept it going after him. Carmen Rigby, 45, who kept the books. Robert Golden, 42, who worked the floor. And Derrick Stewart, everyone called him Bobo, 16 years old, a kid with a summer job and a pitcher's arm, just hired. Around 9 o'clock, Bertha Tardy phoned a retired employee named Sam Jones and asked him to come in and help train the new hires. When Jones arrived about an hour later, he walked into the worst crime scene in the town's history. All 4 had been shot in the head. 3 were already gone. Bobo Stewart, 16, was still breathing. He was rushed to the hospital and he fought for 6 days. On July 22nd, he died too. 4 people, a few $100s missing from the drawer. And no one left inside those walls to say who did it. I want to be precise about what the killer left behind, because everything that follows depends on it. There was no murder weapon. None was ever found. There was no eyewitness to the crime. There was no fingerprint that answered the question, no camera, no confession. Understand what that empty room meant for the town. Winona is the kind of place where everyone is 2 handshakes from everyone else, where the victims' families and their neighbors passed each other at the grocery store and the church door every week, carrying the same unbearable question. A crime this terrible and a case this empty, that combination is dangerous because a town in agony demands a name, and it demands it fast. And the man whose job it was to provide one was the elected district attorney of Mississippi's 5th Circuit Court District. Doug Evans, a white prosecutor in office since before the murders, with a jurisdiction of small towns exactly like this one. Remember how thin the file is. Now watch a name get chosen. Within days, investigators fixed on Curtis Flowers. Why him? He had worked at Tardy Furniture, briefly, and had been let go about 2 weeks before the murders in a dispute over roughly $30 from his paycheck. That was the theory of the case, and I want you to hold it up to the light because 4 death sentences will eventually rest on it. A man with no history of violence, no criminal record of any kind, a church-going gospel singer whose family was known across the county for their music. This man, the theory went, walked across town one July morning and executed 4 people, including a 16-year-old boy, over a lost part-time job and $30. From the first day, Flowers said he had nothing to do with it. He would say it without a single deviation for the next 23 years. But he was the name. And once he was the name, the case began to assemble itself around him, the way a case does when the answer has been written first and the investigation is sent out to find it. Look at what the state built, piece by piece, because you are going to watch 12 strangers asked to kill a man on the strength of it. The gun never found. Prosecutors said the bullets matched a pistol stolen that same morning from a parked car outside a garment plant across town. A gun that itself never turned up. The root, months after the murders, after reward money went public, witnesses began to surface saying they'd seen Flowers that morning, walking here, walking there, tracing a path from his home toward that parking lot and on toward the store. A paper trail of memory assembled long after the fact from a town that had heard for months who the suspect was. The science, a single microscopic particle on the back of Flowers' hand, swabbed hours later, of a kind experts will tell you can come from a gunshot, or from a police car, or a handcuff. And a bloody shoe print at the scene in a common sneaker style, a size that fit Flowers and, as the defense would point out, an awful lot of other people. And the arrest split the town in two. In much of white Winona, the matter was settled the day the handcuffs went on. The DA had his man, and the town could exhale. In black Winona, the churches where the Flowers family sang, the streets where Curtis had grown up in plain view of everyone, the reaction was closer to disbelief. They had known this man his whole life, and nothing in him matched the crime. Two towns, one case, and a line running between them that every jury in this story would be built along. That's it, because that really is the whole case. No weapon, no witness to the crime, no motive bigger than $30. A chain of maybes, each link soft, all of it pointing at a man with no record because it had been built to point at him. Any one of those links alone would embarrass a shoplifting prosecution. Braided together and told with enough confidence, they were about to be offered as proof beyond a reasonable doubt in the most serious charge American law has. In January 1997, Curtis Flowers was arrested for 4 counts of capital murder, the kind of murder that carries the death penalty. He was 26 years old. He would not take another free breath until he was 49. A thin case, though, carries its own danger for the state. It is exactly the kind a fair jury can see through. 12 ordinary people sworn to doubt. That was the danger the state's case could not survive. Which means the story of the next 20 years is not really about evidence at all. It's about 12 chairs in a jury box, and who was allowed to sit in them. One rule before the count begins, because the whole film turns on it. In American courts, each side can remove a certain number of potential jurors without giving any reason. It's called a peremptory strike. And since 1986, a case called Batson, the Constitution has said there is one reason you can never use: race. Strike a juror for being black, and the trial is poisoned. Hold that rule. Now count. Trial 1. October 1997. The publicity in Montgomery County was so saturating that the case was moved 100 miles away to Tupelo. And notice the first strategic choice. Flowers was not tried for the 4 murders. He was tried for one. Bertha Tardy's alone, a smaller, cleaner story, with the other 3 counts held in reserve so that even an acquittal would not end anything. Watch the jury. 12 seats, 12 white jurors in a case pulled out of a county that is nearly half black. The trial ran on the root witnesses, the borrowed ballistics, the particle, and it ran on the prosecutor's voice, filling the gaps in his evidence with the certainty of his telling. The jury convicted and sentenced Curtis Flowers to death. That's one. He was sent to death row at Parchman, the Mississippi State Penitentiary, the most notorious prison farm in the South, to wait at 27 for the state to set a date to kill him. And here is where this story leaves the road you think you're on. Because the conviction did not stand, and the reason it fell was not some technicality. In 2000, the Mississippi Supreme Court, 9 justices of one of the most conservative courts in the South, no friend of death row appeals, threw the verdict out because of what the prosecutor himself had done in that courtroom: misconduct. He had argued facts that were never in evidence, told the jury things again and again that no witness had actually said from the stand. Read that again. The state's highest court looked at Doug Evans' first win and ruled that it had been taken unfairly. By then, Curtis Flowers had spent 3 years on death row on the strength of it. And the remedy for those 3 years? Start over. The gap in the wall? A do-over, run by the same man. Except the do-over had already happened before the reversal came down. While the Tardy conviction was still on appeal, Evans had simply reached for the counts he'd kept in reserve. Trial 2. March 1999 moved this time to the Gulf Coast. A different single count, the murder of 16-year-old Bobo Stewart. Watch the jury. 11 white jurors, 1 black juror. Conviction. Death. That's 2. And in 2003, the Mississippi Supreme Court threw that one out as well. Prosecutorial misconduct again. The same court, the same finding, the same name in the record. Twice now, Curtis Flowers had been strapped to a death sentence. And twice, the highest court in the state had ruled that the man prosecuting him had crossed the line to get it. Add up what that cost the man in the cell. Convicted in 1997, cleared of that verdict in 2000, convicted in 1999, cleared of that one in 2003. 6 years gone, 2 death sentences served in the waiting room of the execution chamber. And in the eyes of the law, neither trial had ever validly happened at all. Most prosecutors never have one conviction reversed for misconduct in an entire career. Doug Evans was now 2 for 2 and completely free to try again. Because here is the loophole inside the loophole. The court could erase his verdicts, but it could not remove him from the case. He was elected. He answered to no judge. Only the voters of his district could ever take the case away from him. And that fact is a loaded gun sitting on the table of this story. Leave it there. It goes off in the final act. Trial 3, February 2004, back home in Winona, and now everything at once, all 4 murders, 1 trial. Watch the jury, because this time, so did the court. 11 white jurors, 1 black juror, again. Conviction. Death. That's 3. And when this one reached the Mississippi Supreme Court in 2007, the reversal changed species. Not misconduct in argument this time. The court found Doug Evans had used his strikes to remove black citizens from the jury because they were black, the exact thing Batson forbids. And it wrote a sentence courts almost never write. The instant case presents us with as strong a prima facie case of racial discrimination as we have ever seen in the context of a Batson challenge. The strongest they had ever seen. That is not an activist slogan. That is the Mississippi Supreme Court describing the state's own prosecutor in the state's own reports. 3 trials, 3 death sentences, 3 reversals, and now the pattern had a name written on it. A machine was running in Montgomery County. Choose the defendant, shape the jury, take the verdict, lose it on appeal, and start again. Each trial funded by the public, each one grinding years off a man's life while he waited on death row at Parchman. The question you should be asking is the question a handful of people in Winona were starting to ask out loud. What happens if you just keep going? How many times will the system let one man run the same play? The answer, it turned out, was at least 3 more. But the next 2 trials would break the pattern in a way nobody expected. Because for the first time, the jury box would not be almost entirely white. Trial 4, 2007. This time, 5 black jurors made it into the box beside 7 white jurors. The first jury in a decade that looked anything like the town. And everything changed. No verdict. The jury deadlocked 7-5, and the split ran almost perfectly along the color line. 7 white jurors voting guilty, 5 black jurors voting to acquit. Look at that number honestly, because it cuts in every direction, and this film is not going to flatten it. 12 citizens of the same county heard the same witnesses, the same particle, the same borrowed bullets, and walked out unable to agree on what any of it proved. A hung jury is not an acquittal, but it is a verdict on the case itself. This evidence does not convince 12 fair people. It never had. The only thing that had ever produced unanimity was the removal in advance of the people most likely to doubt. Trial 5, 2008. 9 white jurors, 3 black. Deadlocked again. That's 2 hung juries in 2 years. And this time the deadlock came down to a single holdout. One black juror named James Bibbs, who was not persuaded a thin case had become a certain one. What happened next should stop you cold, because it is the moment this story shows you its teeth. When the mistrial was declared, James Bibbs, a juror, a citizen doing the duty the state had summoned him to do, was handcuffed in open court and charged with perjury. The prosecution pursuing him, Doug Evans. Think about what a charge like that says to every black citizen of Montgomery County who might one day be called to sit in that box. Vote the wrong way, and the man at the prosecution table may come for you next. The state attorney general's office eventually stepped in, took the case away, and dropped the charge entirely. But the message had been broadcast in handcuffs in a public courtroom, and it did not need repeating. Trial 6. June 2010. Winona. 14 years had passed since the murders. The root witnesses were 14 years older. The case had aged, but it had not improved. Watch the jury one last time. 11 white jurors, 1 black juror. The arithmetic restored to what it had been whenever the state had won before. The deliberations reportedly took around half an hour. Half an hour for 4 capital counts and 14 years of contested evidence. Guilty on all 4. Death. That's 6 trials and a 4th death sentence. And Curtis Flowers, now 40 years old now, went back to the row at Parchman, where he had already spent most of his adult life. As far as the state of Mississippi was concerned, the machine had finally produced a verdict that would stick. And for 8 years, it did stick. The appeal from Trial 6 ground its way upward, while Curtis Flowers passed his mid-30s, then his 40s, in a death row cell. A man now old enough to have spent more of his life inside the case than outside it. The town moved on. The store changed. The machine at last seemed to have won by outlasting everyone. It would have kept winning if the case's most important witness had been telling the truth. Because there is a character I have kept off camera until now, and he is the floor this whole building stood on. His name was Odell Hallman. They called him Cookie, a career criminal from the same county, in and out of Parchman his entire life. Beginning with the second trial, Hallman gave the state the one thing its case never had: direct evidence. He swore that Curtis Flowers had confessed to him. Cell block to cell block, killer to confidant. He told that story on the stand in 4 of the 6 trials. When jurors later explained their guilty votes to reporters, that jailhouse confession was the piece they reached for. Not the particle, not the root, him. So who was Odell Hallman? Follow his file through the same years, and you find a man whose own serious charges kept resolving with remarkable gentleness while he remained useful to the state. A pattern documented across years of court records. Drug charges, gun charges, violence. The file kept growing, and the consequences kept not arriving. Ask yourself what a jailhouse confession is worth when the man selling it is running a tab. 4 separate juries were never really given the chance to do that math. And then in 2016, the state's star witness showed the world exactly who he was. Odell Hallman took a gun and murdered 3 people: his ex-girlfriend, Marquita Hill, her mother, Carolyn Ann Sanders, and a man named Kenneth Loggins, and wounded a 4th. He pleaded guilty about 2 weeks later. 3 murders. Life in prison. Sit with this. The witness whose word put Curtis Flowers on death row 4 times went on to commit the very kind of crime Flowers was condemned for. While Flowers, who had never heard anyone on any record ever produced, sat in a cell measuring his life in appeals. And the floor had one more board to give. In 2018, investigative reporters who had spent a year in Winona pulling this case apart got Odell Hallman on a recorded line from prison. And on tape, the state's star witness said this: "As far as him telling me he killed some people, hell, nah, he ain't never told me that. That was a lie. That was a lie." 4 trials, 4 juries told about a confession that, by the teller's own recorded words, never happened. The only direct evidence in 6 prosecutions, gone in 1 sentence. The tower was standing on nothing, and now the nothing had said so out loud. The question was whether anyone with power would listen. The answer came from 2 directions at once: a microphone and the Supreme Court of the United States. The reporters were from American Public Media. a team led by Madeline Baran, and a podcast called In the Dark. In 2018, they did what 6 trials somehow never had. They checked everything. They rewalked the route and found the state's timeline of sightings dissolving. Key route witnesses recanted or contradicted themselves on the record. They took the ballistics to independent firearms examiners, who would not stand behind the certainty a jury had been sold. They asked what a single particle on a man's hand, swabbed hours later, actually proves, and the answer was, nothing a life should hang on. Piece by piece, the case that had consumed 20 years and 4 death sentences came apart on tape, in public, for millions of listeners. But their most devastating work was arithmetic. Jury selection records in rural Mississippi are not sitting in a database. They are ink on paper in courthouse storerooms. The reporters went and got them, county by county, trial by trial, across Evans' entire district, and built the data set nobody in power had ever bothered to build. More than 6,700 jurors, 225 trials, a quarter century of records. The finding. Across his tenure, Doug Evans' office struck black prospective jurors at nearly 4.5 times the rate it struck white ones. Half of all eligible black jurors struck, 11% of white ones. And the disparity held even when black and white jurors gave the same answers to the same questions. Not one case, not one bad afternoon, a pattern running the length of a career. The same pattern the Mississippi Supreme Court had called the strongest it had ever seen, now measured across everything the man had ever touched. And that is what was sitting in the open when Flowers' appeal from Trial 6 reached the United States Supreme Court. June 21, 2019. Flowers versus Mississippi. 7 justices to 2 in an opinion by Justice Brett Kavanaugh, a Trump appointee writing for justices across the court's entire ideological spectrum. The court threw out the 6th conviction, and it did not do it quietly. The opinion walks through Doug Evans' 6 trials by name, and then it does what this film has been doing all along. It counts. In the 6 trials combined, the court wrote, the state used its strikes against 41 of the 42 black prospective jurors that it could have struck. In the first 4 trials, 36 black prospective jurors came up. The state tried to strike all 36. In Trial 6, the state struck 5 of the 6 black citizens in the pool, and the court noticed how it had asked those 5 black prospective jurors 145 questions, hunting for any excuse, while asking the 11 seated white jurors a total of 12. The numbers speak loudly, Kavanaugh wrote. And then the sentence that will follow Doug Evans forever. The state's relentless, determined effort to rid the jury of black individuals, the court wrote, strongly suggests it wanted to try Flowers, ideally before an all-white jury. Equal justice under law, the court said, requires a criminal trial free of racial discrimination in the jury selection process. 2 justices dissented, arguing the strikes had race-neutral explanations. The majority was steamrolling, and were answered by the opinion's plain refusal to look at Trial 6 in a vacuum. You cannot understand Strike 42, the majority reasoned, without the 41 that came before it. The count had made it all the way to the top of American law, 41 out of 42. The 6th conviction was gone, and this time, the machine could not simply reset because now the whole country was watching it try. December 16, 2019. A Mississippi courtroom, the same circuit judge who had presided over the later trials, and for the first time in 23 years, bail. $250,000, an ankle monitor, and Curtis Flowers walked out of jail into the December air, a 49-year-old man who had entered the system at 26. Every step of his adult life to that point, every appeal, every reversal, every retrial had happened in custody. This was the first door in 23 years that opened outward. Weeks later, Doug Evans and the prosecutor of all 6 trials finally let go of the case, recusing himself. It went to the Mississippi Attorney General's office, which did what a fresh set of eyes was always going to do. On September 4, 2020, the state dropped every charge, dismissed with prejudice, the legal words for never again. No 7th trial. Not ever. After 6 trials, 4 death sentences in 23 years, the state of Mississippi walked away from the case against Curtis Flowers without a conviction to its name. What does a state owe a man for that? Mississippi's answer is written in its own statute, $50,000 per lost year, capped at 10 years. Curtis Flowers lost nearly 23. In March 2021, a judge awarded him the maximum $500,000, paid in yearly installments, compensation, by law, for less than half the life that was taken. He sued Doug Evans in federal court. The case settled in 2023, terms undisclosed. And Evans himself? Understand this clearly, because this film will not lie to you to make the ending feel better. He was never charged with anything, never disciplined by the bar. Prosecutorial immunity held. The man whose conduct for reversals in the Supreme Court of the United States wrote into the permanent record kept his office, his license, and his pension. But the record was now public, and the people of his district had heard it. Remember the loaded gun from Act 2? Only the voters could take the cases away from him. In November 2022, Doug Evans asked those voters to elevate him, to make him a circuit judge, a robe above the courtroom where all 6 trials ran. The district that had employed him for 3 decades gave its answer, 70% to 30 for his opponent. A landslide against the man the numbers had caught. 7 months later, he retired as district attorney, gone before his term was up. And the reckoning has not closed. In March 2025, a veteran attorney discipline official petitioned the Mississippi Supreme Court, the same court that reversed him 3 times, to suspend Doug Evans' license to practice law. As of this film, that question is still open. The record he wrote is still following him. So run the final count. 6 trials, 4 death sentences, all 4 erased. 2 hung juries, 1 prosecutor, whose name is now fixed in a Supreme Court opinion beside the words relentless and determined. 23 years of one innocent man's life, traded for a $500,000 cap. 0 criminal consequences for the man who ran the prosecution. That is the whole ledger, except for the last line, and the last line is the one this story will not let you look away from. Nobody was ever held accountable for the murders of Bertha Tardy, Carmen Rigby, Robert Golden, and 16-year-old Derrick Stewart. The case is officially unsolved. Whoever walked into Tardy Furniture on July 16, 1996, has never answered for it. Because for 23 years, the full weight of the state of Mississippi was aimed at proving a theory instead of finding the truth. 6 trials didn't just nearly kill an innocent man. They spent the only investigation those 4 families will ever get. Curtis Flowers is free today. He sings again. He got his life back at 49. And what the record shows at the end of all the counting is that he is the only man who ever paid for what happened at Tardy Furniture, and the only one who owed nothing. One more number, and I'll let you go. 50% of eligible black jurors struck against 11% of white ones for a quarter of a century in one small district, before anyone with a microphone or a gavel added it up. Winona is not the only town with courthouse storerooms full of paper that no one has counted. That is not a Mississippi story. That is a math problem sitting right now in every state in the country. If you believe a jury of your peers should mean all of your peers, hit like so the next count comes out different.